Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. This is my Facebook page, guys. If you want to find me and have questions about foreclosures or motions that are filed, you can send me an email to foreclosurehelp777@gmail.com or find me on my Facebook page. And today we're going to talk about Carrington's case. You can find him in the New York Supreme Court. His docket number 11234-2009. Look in his case here, and you'll want to go to the latest and greatest. You can see what he filed is a motion for summary judgment, and it's right here. He's got his notice of motion for summary judgment, affidavit, and 3 exhibits. So let's take a look at what he's doing here. Okay, the table of contents for his motion to summary judgment. You got introduction, legal standard, procedural background, argument. Plaintiff failed to comply with RPAPL 1304. The plaintiff lacks standing to foreclose. Plaintiff's evidence is admissible hearsay. Facts that are not in dispute, and conclusion. And guys, if you've been following Carrington's case, you know that he is the defendant in a judicial foreclosure in New York City, and that he's been fighting for 16 years. And so, you know, the last thing he filed before the summary judgment was a motion in limine to suppress and exclude defective documents from them being able to foreclose with. So we came across some things that are interesting, and we think that's enough for him to get a summary judgment in his favor. So let's take a look. Alright, here's his table of authorities, case law he's using, and then basically his memorandum of law in support of summary judgment. And he says that this memorandum of law is submitted in support of defendant's motion for summary judgment pursuant to CPLR 3212 due to plaintiff's failure to comply with the 90-day notice requirement under RPAPL 1304 and for lack of standing. And it says down here about a footnote about the motion for summary judgment that can be filed within 120 days of the note of issue, which, as you know, was filed I guess it was in February or March. But anyway, it's definitely within that time frame, so he's allowed to do this. Legal standard. CPLR 3212 allows for summary judgment when there are no genuine issues of material fact and the moving party is entitled to judgment as a matter of law. Compliance with RPAPL 1304 is a condition precedent to the commencement of a foreclosure action. Plaintiff failed to comply. The failure of plaintiff to comply with RPAPL 1304 will result in the dismissal of a foreclosure complaint. C. U.S. Bank N.A. versus Beimer. This issue was raised in an affirmative defense by the defendant. C1 West Bank FSB versus Rosenberg. Indeed, proper service of the notice containing the statutory mandated contact is a condition precedent to the commencement of a foreclosure action. See U.S. Bank N.A. versus Terramino. And then it says, although defendant argued that plaintiff failed to comply with RPAPL 1304, the plaintiff failed to demonstrate its compliance with the statute as part of its prima facie case. See Bank of America N.A. versus Wheatley. Whenever you do these kinds of motions, like for summary judgment, you have to have a lot of case law to back up what you're saying. And that's what he's doing here. Procedural background. On April, and this is just a timeline of everything, guys. April 25th, 2008, the plaintiff, Wells Fargo Bank, filed the first foreclosure complaint under index number 1284008. On February 6, 2009, Judge Robert Miller wrote an order dismissing the case because Wells Fargo did not have standing to foreclose. Now we can go through all these points, but I kind of want to go through them quickly. But basically, this is a timeline of everything that's been going on. You can see on May 18, 2018, Judge Nipel granted the summary judgment motion in favor of the plaintiff. On September 10, 2019, defendant filed a notice of appeal. On November 8, 2023, the appeal was reversed with costs awarded to the defendant. The foreclosure sale was vacated. On December 4th, 2023, defendant filed a motion to dismiss. On February 27, 2024, plaintiff filed a cross motion for summary judgment. On March 5, 2024, a hearing was scheduled on the motion to dismiss and cross motion for summary judgment, and on March 7, 2024, Judge Nipel wrote an order which denied both motions. On March 12, 2024, defendant filed a judicial notice explaining that the plaintiff had committed fraud on the court, Exhibit G, which was filed on February 29, 2024, pages 25 through 27 and pages 40 through 42, and Exhibit 1, Document 17, filed on February 27, 2024, see pages 19 through 21. There can only be one promissory note, and plaintiff has presented 3 different notes. On March 26, 2024, the plaintiff filed a note of issue with certificate of readiness that stated discovery was complete and the case was ready for trial. On April 2, 2024, the defendant filed a motion to strike the note of issue with supporting affidavit stating that discovery was not completed and the case was not ready for trial. On April 2, 2024, defendant filed a motion for clarification asking the judge to explain why the motion to dismiss was denied. On April 18, 2024, Judge Nipel denied the motion to strike note of issue and motion for clarification. On May 29, 2024, defendant filed a motion in limine in order to suppress and exclude the defective documents that the plaintiff is using in order to foreclose. Argument. Plaintiff failed to comply with RPAPL 1304. RPAPL 1304 mandates that a 90-day notice be sent to the borrower before initiating a foreclosure action. The notice must be mailed at least 90 days prior to filing a foreclosure action. In this case, the plaintiff mailed the notice on May 7, 2009, which is the exact same date that the foreclosure action was filed. This violates the statutory requirement. The plaintiff filed a copy of the 90-day notice, which is Document 49, Exhibit O, filed in NYSEF on 2/27/24. A copy of this 90-day notice is hereto attached as Exhibit A. Consequences of noncompliance. Failure to comply with RPAPL 1304 renders the foreclosure action procedurally defective. Courts have consistently held that noncompliance with this statutory condition precedent necessitates dismissal of the foreclosure action. See Hudson Bay Savings Bank versus De Pasquale, however you say it. RPAPL 1304 notices must contain certain statutory language in a specified type size and must be mailed in a specified manner. Must include a correct reinstatement figure, among other requirements, in order to fully comply with the statute and survive judicial review. Following information regarding the 90-day notice was mailed to the defendant is stated by the plaintiff on Doc 34, filed in NYSEF on 2/27/24. The affirmation of Richard Schweiner on page 6 of 8 under number 15, it states the following. Now this paragraph just basically states that this 90-day notice was indeed mailed on May 7, 2009. So again, it's more evidence that they in fact mailed it on the same date as this foreclosure action was done. Now we talk about standing. The plaintiff, Wells Fargo, must have standing in order to foreclose. Lack of standing to foreclose is a legal concept that refers to a situation or a party attempting to foreclose on property does not have the legal right or authority to do so. This can happen for various reasons, including no ownership interest. The party foreclosing, Wells Fargo, as trustee for the Soundview 2007 OPT1 Trust, has not provided any prima facie evidence that it owns the mortgage or the Seaman note, therefore has no right to foreclose. And we get into all these things here: no legal authority, broken chain of title, failure to comply with regulations, the 90-day notice, of course. The plaintiff has not presented prima facie evidence, and then plaintiff's evidence is admissible hearsay. And then we have a nice little footnote explaining what prima facie evidence is. Okay, and then we have all of these notes have different defendant's forged signatures. And it basically goes over that stuff again. And then we talk about the fact that there's no endorsement by the plaintiff, Wells Fargo, or to the purported Soundview 2007 OPT1 trust. Copies of these 3 different SEMA notes are attached here to as Exhibit D. And then we talk about the assignments of mortgage. I'm going to get into the assignment. It's basically the same stuff that we talked about on his motion in limine, talking about those defective documents. So let's kind of get to the end of this, guys. Facts that are not in dispute for a summary judgment to be granted. Look. The foreclosure action was filed on May 7, 2009. The 90-day notice under RPAPL 1304 is dated May 7, 2009. The plaintiff submitted 3 forged SEMA promissory notes. The assignments of mortgage are both fatally defective. None of these 3 SEMA notes are endorsed by Option 1 or to Wells Fargo. None of the allonges are attached to any note. And then basically it kind of reiterates the same stuff here. It is not disputed by either plaintiff or defendant that this foreclosure action was first filed in court on May 7, 2009. It is also not disputed that the 90-day notice required under RPAPL 1304 was mailed to the defendant on May 7th. So it's basically restating the same things again. So, and then at the end here it says, conclusion. Wherefore, based on the foregoing reasons, the plaintiff respectfully requests that this court grant summary judgment in favor of the defendant and dismiss the plaintiff's complaint with prejudice due to the fact the plaintiff lacks standing and for failure to comply with the 90-day notice requirement under RPAPL 1304. Okay, guys, so that's pretty much it with that. So if anybody has questions about this, you can send me an email or leave a comment. I appreciate your support. Thank you for liking my channel, everybody, and have a wonderful, blessed day.